Let me see it.
Good morning. I think we're waiting for Judge Mize, who may be having some tech issues. So, oh, there he is.
That's a great picture.
A lot of Photoshop.
All right, the session of the 6th District Court of Appeal is back in session. We are doing case number 23-118, SFR Services, LLC, as assignees of Michael Carbonara and Mary Carbonara versus Tower Hill Prime Insurance Company. Appellants, are you ready to proceed?
Yes, Your Honor.
Okay, and how much rebuttal time would you like?
I'll say 5 minutes, please.
Okay, thank you.
Thank you.
And you may proceed.
Thank you so much. May it please the court, justices, Mr. Jones.
We're not justices. At least one of us might be soon, but judges.
Sure, I did. Honorable appellate judges. I was just trying to I'm going into my time to seek flattery, but that's not an indication of the weakness of my case. So
Okay.
just don't take it as that. So this is a very, this case took an interesting path to the court. I'm not going to belabor the background. It's in the briefs. Full trial, jury was unable to reach a verdict. Mistrial was great.
Yeah, we know all
Okay.
that.
Yeah. Okay. All right. So the case got way off track from the beginning. So, there's two categories that I think we need to focus on. One is, and the majority, if not all of the cases cited by the parties deal with whether the amount of damages established at trial creates a breach. And so I'm going to back up and I'm going to explain why, if Tower Hill wanted to make a directed verdict based on the case law that it relied on and continues to rely on in its brief, based on the first question of the verdict form, which was, I believe, did the insured prove that Tower Hill did not pay sufficient amounts when it didn't pay over the deductible, which I think was $9,600 and change. But instead what they did was, this was kind of a moving target, the whole case. So that the parties concede that the complaint was just alleged generally to say that they were collecting amounts owed. And then that kind of that turned into, the repairs haven't been made, so they're limited to ACV. And then that's when both sides kind of just gravitated towards this damages issue. So, the way I see it,
Let me just interrupt you.
Sure.
Apparently, we got started just a little bit early, and so the recording on this for YouTube, I might have gotten started a little late, but I just wanted those who are listening that to catch up that they're really haven't missed anything in terms of the substance of the argument. So let's talk about some specifics.
Sure.
First of all, you understand that you had the burden of proving damages, right?
Absolutely.
Okay, but you did have in your case in chief, you had Tower Hill's depreciation calculation, correct?
We had the estimate that included the original depreciation calculation. Yes, Your Honor.
Okay. And effectively, it seems to me that what you're arguing, and correct me if I'm misstating your position, is that calculation determined a percentage for depreciation, and that was sufficient for the jury to make a determination as to actual cash value for replacement of the roof. Is that your position?
I think that's sort of my position. I mean, obviously there was a lot of testimonial evidence, and there were 3 separate estimates submitted into evidence by the by my client.
Right, but
But
none
I
of
think-
those accounted for depreciation. Is your position that you didn't have to account for depreciation in terms of establishing damages?
That is our position, especially when you look at the provision in this policy, that includes a caveat that the actual cash value is the cost to repair or replace covered property at the time of loss or damage, whether that property has sustained partial or total loss or damage with material of like kind and quality, subject to a deduction for deterioration, depreciation, and obsolescence as determined by us. So, the fact that that Tower Hill is essentially trying to put a burden on the insured to calculate actual cash value, I think it flies in the face of the loss settlement provision or the definition of ACV.
Right. So what case do you cite in support of your proposition that as the plaintiff in the lawsuit, you didn't have to account for depreciation because that burden would have been on Tower Hill?
Well, I'm not necessarily sure that there's a specific case. I think that segues into the argument that I started off with, but I think it's distinguishable. I think it's important to understand the language in that policy. So it doesn't put the onus on the insured to come up with, an actual cash value to establish damages. So backing up, there's very little case law on this issue. There's two cases from the third that everyone wants to talk about and goes back and forth over, the more recent Vasquez case and the TO versus Citizens.
Counsel, I'm waiting to continue, but I just want to ask before we get into those cases in the third, did either of those cases from the third concern a policy that stated that you had an actual cash value, and that's what it started, subject to then change, determined based on depreciation, determined solely by the insurance company?
No, TO said for a dwelling, the insurer must initially pay at least the actual cash value, less any deduction. The insurer shall pay any remaining amounts necessary to perform such repairs. That I have Vasquez quite at my fingertips. Have the case, so I can get that language. So I'll get back to that, but I can tell you unequivocally that
is this an issue of first impression?
I don't.
No, you have a situation where the burden of proof is obviously always on the plaintiff, or normally on the plaintiff. Here you have a policy that said the actual cash value, what is recoverable, is the cost of repair, subject to being deducted for depreciation as determined solely by the insurance company. Has there ever been a policy like that construed by any DCA in the state?
Not that I am aware of off the top of my head. I am looking at because I think this is the ACV provision in Vasquez. Keeping in mind too that the procedural posture of that case was very different. It was filed as a deck action on whether or not the carrier had paid ACV. And actually, I will say, if my notes are in order, Vasquez does say the cost to repair or replace covered property at the time of loss, and it does have subject to a determination for deterioration, depreciation, and obsolescence as determined by us. So I want to frame this in the way, I've been arguing it to trial courts, and I think that this is really the only logical conclusion. So you have TO that says if there's a breach of the policy, that loss settlement provision goes out the window. Well, there are breaches of policies by carriers when they underpay a claim. And so when you're dealing with a situation like this, where actual cash value, just unilaterally determined by the carrier, was paid, the way this should have played out, and it's supported by the multitude of cases, including the completely distinguishable but seemed to be important to the trial judge, that CCR case from the Middle District, those cases are all couched in, the breach was the ACV, was the underpayment of the ACV of breach. And that's really the only way that we can make sense of all of this. And I'll just kind of walk you through the conclusion as to why, because, keep in mind the directed verdict motion was just directed solely towards damages. So I think that's an entirely different animal. But, if we were talking about, if we were talking about just apples for apples, if it's a denied claim, once you prove coverage, you've proven a breach. If it's an underpayment of ACV, once you've proven that the ACV was more, or you you submit competing estimates and the jury determines that's a breach, in my mind, that should take, and consistent with TO, that should take the loss settlement provisions off the table and allow the insured to pursue, a full cost of their damages, because you don't get a second bite of the apple. I was, in trial 6 months ago, and, the carrier was, advocating for this same sort
Actually,
of,
we don't know. You keep saying, but we don't know. That's why we're here.
Okay. So, the only way to make this fair is, what proves a breach under these two scenarios, because I think that all of the members of this panel have either been serving on the appellate courts or the circuit courts and have seen this issue repeat itself time and time again. The only it used to be that immediate on the underpayment, that was a denied claim. We've kind of moved past that. We've said, well, they need to have a second look at things. That's when we get into Goldberg, which I think is completely irrelevant to this case. But, the trial courts need guidance on how to deal with this, because this ACV argument has been used to, derail multiple trials. And I just don't see, we have a situation here where I think it compels reversal as to the court's conclusions on damages. And the court even citing to the Middle District case, which is, again, utterly distinguishable, he notes that it was, the case, he cites to it as far as damages, but the case itself says that the failure to establish the ACV damages was the actual breach. So, we're here talking about, was there sufficient evidence in the record for the jury to return a verdict? I mean, they asked for a calculator during the jury deliberations. They had 3 estimates from the plaintiff.
Just as a practical matter, I think that fraudulent letter from the city of Estero might have just killed you guys at trial, but that's not going to help us resolve this case. So I'm trying to understand, your argument. Your first argument is that we don't have to establish depreciation because of the terms of the contract. Correct? And
Correct.
Is it alternatively that even if we did, that we presented through the introduction of Tower Hill's calculation sufficient evidence to have established that in any event?
Establish what in any event? I'm sorry.
Depreciation. If you
depreciation. Yeah, I mean, I think that, depreciation, and it was discussed, I think there was a jury instruction on it. It's, especially considering the policy puts the onus on the insured to calculate it, the evidence or the estimate from the carrier was in there. It very clearly had a, percentage of depreciation. And, there was also, just testimony about the age of the
we
roof,
don't know.
that sort of thing.
All right.
Well,
Yeah, just before
record.
we let you go, I just want
to reemphasize that I just think, this might be, we might need to approach this in a different way if the directed verdict was, there's not enough evidence to establish the breach. That's not the path Tower Hill took. And there's, certainly some
breach includes
backpedaling.
damages. Breach includes
Right, but
damages. That's in,
right.
yeah.
But the judge specifically granted directed verdict on damages. And I've looked at that, a million times. He doesn't reach the question of whether there was, a breach. He doesn't reach the question. All he says was there's not sufficient evidence of damages for the jury to get to define. And I think that flies in the face of, even cases, just to use an example, where only one side has an expert and, the third district has said, vigorous cross-examination sometimes can be enough to get the case to the jury. I mean, the jury, certainly understood the task and certainly had enough evidence that they could have, reasonably turned a verdict, assuming they agreed that the, policy had been breached, assuming they agreed that no exclusions had been established. They could have, this is just not a case where there was no evidence that a reasonable jury couldn't return an amount of damages, and that's the narrow focus of
the
argument.
depreciation calculation by Tower Hill, was that for the whole roof or for part of the roof?
It was just for whatever the the 180 tiles, but I still think
and you were seeking the entire roof to be replaced, correct?
Actually, the complaint just said the carrier had failed to pay amounts due under the policy.
Your experts
ACV,
said the whole roof. Your experts said the whole roof needed to be replaced.
correct.
Right. Okay.
Yeah, but then there were stipulations that because the repairs hadn't been done, they would ask for ACV, and that was stipulated on the record. We tried to stipulate to a 21% reduction, and then that kind of gives me to my final point before I save the rest of my time for rebuttal. The reductions based on policy terms are routinely dealt with after a verdict. So to the extent there was a basis for a remittitor, or just the verdict to be reduced by the deductible, that sort of thing. But again, in these cases, there's two types of paths. It's a denied claim. Once you prove coverage, that's the brief. It's an underpayment, depending on if you've made the
If you want
repairs.
some rebuttal, you better stop.
I'll stop.
Okay.
Appellee's counsel, you may proceed.
Good morning, may it please the court. My name is Ryan Jones and I represent Tower Hill. The trial court directed a verdict in favor of Tower Hill, and we're asking this court to affirm.
Let me talk about, let me just, assuming that, that your contractual provision that said depreciation was up to you all to determine solely at your discretion. Let's just talk about, what is depreciation?
Well, depreciation in the broadest sense is calculating the wear and tear and age that a building component goes through.
We look at the life cycle, of the roof, and we look at how long the roof has been on, and that gets us to a calculation as to depreciation, correct?
That's correct, Your Honor.
Now, why would it make a difference whether it was 50 tiles or the entirety of the roof? Isn't the analysis for depreciation the same under either of those scenarios?
Not necessarily, Your Honor, because the
Well, did you have any evidence that there would be any distinction between depreciation on part of the roof versus depreciation from the entirety of the roof?
No, Your Honor. And as a matter of fact, that's part of the problem, because it is.
Why don't you? I'm just trying to understand why would there be a distinction between 50 tiles and 300 tiles or whatever in terms of depreciation when a depreciation is simply life expectancy versus the amount of time the tiles have been on the roof.
And as part of answering Judge Cohen's question, can you tell us whether there's any asset that you're aware of where a part of the asset, you have a single asset and you depreciate part of it at a different rate than the remainder of the asset, even though it's all identical?
Yes, and as a matter of fact, I think that is the answer to Judge Cohen's question, because each component has to be analyzed separately. And it is, as we were discussing, it's the life cycle of, for example, a tile, as opposed to underlayment, as opposed to the grout and mortar, as opposed to the sheathing. All of that has to be factored into separately before you reach the appropriate level of depreciation.
You think a plaintiff in this situation has to put evidence on as to each of those components to establish depreciation? Is that your argument?
Our argument is that
That's a yes or no. Is that your argument?
Yes.
Yes. Oh,
Yes, Your Honor,
please.
there must be some evidence of what the depreciation needs to be. But in this particular circumstance, we don't need to get there. And here's why. Everything so far has focused on starting with SFR's estimate and trying to work backwards to get the actual cash value. But the flaw in the evidence that was presented is best exemplified by starting with the policy terms and working forwards. What I mean by that is that the policy covers direct loss only if the loss is physical, and it requires Tower Hill to pay the actual cash value of the insured loss. The exact phrasing of those two provisions that I just recited was addressed in the Vasquez versus Citizens case. And the key takeaway from the Vasquez case is that the insured loss was defined. The insured loss, as it's used in the policy, means the property that was actually damaged. So that's what we need to do in this case, is find, in the light most favorable to SFR, the property that was actually damaged. So we can go to their expert's testimony, who stated that there were 25 roof tiles that were actually damaged by Hurricane Irma. The question then is, what is the cost to repair or replace those 25 roof tiles? And I'll leave depreciation out of it for the time being.
Yeah, I'll tell you what, under your analysis, no homeowner could ever get a roof fixed, because when a hurricane hits, and that's what happened in this case, the fact is by statute, if 25% of that roof is damaged, the entire by statute, the entirety of the roof has to be replaced. Under your analysis, well, only 25% of the tiles were damaged. So to establish damages, all we got to do is value that 25% of those tiles, because those are the only ones actually damaged.
Not exactly, Your Honor. The 25 tiles that were actually damaged, that's the property that was actually damaged. That's the first sentence of the loss payment provision. The Tower Hill has to pay the actual cash value of the insured loss, which is the property that was actually damaged. The next sentence is where Your Honor's concern is addressed, which says, we will then pay any remaining reasonable and customary amounts necessary to perform such repairs as the work is performed and expenses are incurred. That refers to the additional tiles that may need to be replaced. Now, in this case, the expert testified there were only 25 total tiles, not percentage, 25 total tiles off the whole.
So let's play this out. So under your analysis, then a homeowner would have to bring an initial suit for the 25 tiles, even though, let's say there's 100 tiles total on the roof. Even though we know the entirety of the roof has to be replaced, the initial claim can only be for those 25 tiles. And so they have to, and your company says, well, we're not going to pay that because that's under the deductible. So they have to bring one suit for that, recover on that, and then they have to have the roof repaired, and then bring a second suit to get the cost for the remaining tiles. Is that what the process that you envision?
Not necessarily, Your Honor. It could be done all at the same time. And the way that it would work is if the insured goes to the county or whoever it is that is the final holder of the permit and says, I need to replace 26% of my roof. The county would say, I'm sorry, you can't do that. You must replace the entire thing according to the Florida Building Code. The insured would then go back to their contractor, whoever that may be, and say, I need a total estimate to do all of this work.
Counsel, they don't need to go to the county to know the law. I mean, if that's the law, that's the law, right? I mean, if you're going to a roofing contractor and the roofing contractor presumably wants to comply with roofing laws, and you say, I want an estimate to replace 26% of my roof, and the roofer says, well, that's illegal, I can't do that. I mean, could you even get a roofer to give you an illegal roofing estimate? I mean, it is illegal to replace 26% of a roof, correct? So how are you going to get an estimate to do something illegal?
Well, Your Honor, I was giving a hypothetical there because in our particular case, if we had to replace 25 tiles, that wouldn't reach that threshold, and that could be done. And the hypothetical I was saying is if there is more than 25%, so either through the county or through a roofer or whoever the case may be, the insured says, I cannot replace this roof, I need the whole thing to be replaced. Here's my contract with the roofer. They could
Well,
contact
but
the insurance
the
company.
reality of replacing tile roofs versus shingled roofs is that you don't stop just at those tiles. You can't as a contractor, there's no way that you can say, all right, I'm just going to replace these 25 tiles, because that's not how repair of tile roofs work. Say that 10 times faster.
And I agree with you, Your Honor, and I think that illustrates the point that we're trying to make. And plaintiff's, SFR's expert testified to just that. He said you can't replace just 25 tiles because of what he called a cascading effect. You need to replace the tile above that and above that and above that until you reach an edge or a ridge. And he never identified the number of tiles that needed to be replaced. So there is no way that we can tell how many tiles need to be replaced in order to identify the actual cash value of the loss. If he had said, for example, once you replace the cascading effect, there are 1,000 tiles that need to be replaced. That takes you over the 25%.
Well, he testified that it was over 25%. That you couldn't replace that. You could not repair this roof and stay below the 25%. That testimony is in evidence.
That's exactly right, Judge. And that also proves the point, because the actual damage, or let's say
Proves the point for who?
Excuse me?
Proves the point for whom?
Proves the point for Tower Hill. Because the evidence, even if we assume that all of the additional work to get to over that 25% constitutes damage, that is a different coverage under the policy than this actual cash value. And this is addressed in the Florida Supreme Court's Savio.
Whether it's a different coverage goes to how you replace the cost to repair, right? Because what you're saying is the cost to repair is only, the specific part that's damaged. But if it is illegal to replace only the specific part that is damaged, there is no way to do that. There is no way to repair the roof without doing the whole roof, because for legal reasons, that it is not possible. You cannot do that. If it is legally mandated to replace the whole roof, then that is the only way you can replace the whole roof. There is no other cost available to the insurer other than doing the whole roof by law.
That's exactly correct, Your Honor. And that's what's referred to as ordinance and law coverage. And that's what was addressed in the Florida Supreme Court's Savio decision. And it said the ordinance and law coverage kicks in after and as a separate coverage to that which is the direct physical loss. And at trial, SFR conceded that it had not undertaken the repairs, so it did not get ordinance and law.
Right, because it would require a homeowner to expend a huge amount of money.
That's
which
correct.
is kind of defeats the purpose of having coverage.
Counsel, before you run out of time, I want you to address and I can save a little bit of time. Sorry, I'm thinking of the 5 minutes. I want you to address the policy language, because you said let's set aside the policy language, and I don't want to do that. It says the cost to repair or replace the covered property at the time of loss or damage, and then it says subject to. So it sets up a two process. So you calculate the cost to repair, that's one thing. Mm-hmm. And then it says, once you have that number, subject to deduction for deterioration, depreciation, and obsolescence as determined by us. So like contracts can do, they gave a specific definition here that even if that wouldn't be the normal definition that is available in the law or to us, the parties contracted their own definition. And the definition they contracted for was depreciation as determined by us. So for purposes of this policy, depreciation is a number only you can determine. Okay. So what possible, and I can understand why I can see why you'd say they could put on evidence of depreciation generally. But under the language of this policy, what evidence could they ever put on that constitutes evidence of the depreciation determined by you?
They could use the same program, and there are often folks.
It doesn't say how we would do, hold on, counsel. It doesn't say as determined the same way we would, or how we would like, which would require mind reading, by the way. It says as determined by you. It says you must determine it, only you. So how could they ever put on evidence of a number that by definition is something you must determine?
The way they would do it, Your Honor, is they would put in evidence of the scope of the damage that was actually done to the property. And from
counsel, that doesn't tell the depreciation that you determine. I want you to answer my question. Don't avoid it. Under the policy, they must put in evidence, according to you, of depreciation determined by you. What evidence would constitute competent substantial evidence that the plaintiff could put in, the insured, of the depreciation determined by you? Not depreciation, depreciation determined by you.
The answer, Your Honor, is testimony from the corporate representative. If the corporate representative for Tower Hill was presented with an estimate for a scope of the 25 tiles plus whatever the additional cascading effect tiles were, and said, this is our scope, how do you depreciate that? Whatever that answer is.
Hold on. Depreciation concerns a specific roof, right? And I don't know of any discovery tool where they can make you do something. Now, if you've determined depreciation, they can say, give it to us. They can't make you send somebody out there and determine depreciation, right? Like when you send somebody an interrogatory, you ask them a deposition question, they have to give you all information they have. You can't compel them to create new information. So if your client has not sent somebody to this roof and looked at the depreciation, they can't make you.
They could ask the question. If we refuse to answer, then we walk right into the trap that Your Honor has just outlined, because then there's no way that they could do it.
Not a trap. This is your policy language.
Yeah, you wrote this policy, counsel. You chose to define depreciation not as many people might define it, and not according to how most people would think of it. You chose to define depreciation as a number that may be determined solely by you.
That's correct. That's correct. It is to be determined solely by Tower Hill when we're talking about the depreciation for the actual cash value. But it's very important not to read just that section of the policy. We have to read what we're determining the actual cash value.
No, I'm sure you want us to not just read that portion of the policy.
Well, I'll tell you what, Your Honor, for argument's sake, if Tower Hill is forced to not rely on that provision of the policy, if we have to look at other provisions of the policy and say that the depreciation issue is not somewhere we're going to prevail, the outcome doesn't change. And the reason it doesn't change is because the actual cash value applies to the insured loss. And the insured loss is the property that was actually damaged. That's either the 25 tiles or the 25 tiles plus
and that is defined as the cost to repair or replace that covered property. And the only legal way, there is no legal avenue available to them to replace that, to repair or replace that property that doesn't involve the whole roof. At least that's the factual. I mean, that's for a jury to determine, but that's the allegation. And there was evidence in the record, from which a jury could make that determination. If they go to a roofing contractor, the roofing contractor cannot give them an estimate for work that is illegal. There is no legal way to replace just those 25 tiles or just the damaged tiles.
And it's a two-step process, Your Honor. And I think we're zeroing in on where the rubber meets the road. The first step is
where the tile meets the roof.
Or where the tile meets the roof, exactly.
Right.
The first step is to determine how many tiles have to be repaired. And for ease of argument, let's say it's the 25. The 25 tiles, if that exceeds the 25% of the roof, then we move on.
No, that's an awfully, that is so simplistic that under Tower Hill's, if that's Tower Hill's position, boy, I feel bad for anybody who's got Tower Hill homeowners insurance, because you could never get your roof properly and legally repaired.
Well, you could, Judge, and the reason that you could is just like the Florida Supreme Court said in Ceballo, is once that replacement cost value or once the initial coverage is established, then the ordinance and law kicks in. So the trial that we had in this case to be over actual cash value is to establish that the scope is more than 25%.
So do you think that then you'd have to have two trials? So let's say that, the jury comes back and against you. Do you have to have a second trial? Because at that point, all you've done is to establish the 25% of what you've termed the tiles that were damaged. And we know it can't be done. Do you have to have a second trial? Tower Hill says, well, no, you could, it's not going to cost you 110 or 163, depending, how much they waffle with Ms. Giassi's, estimates. But, do you have a second trial?
Not necessarily, Judge. There's two ways.
Not necessarily, but if Tower Hill contests it, you'd have to.
Not necessarily, Judge. There's two ways to do it. Number one,
But not necessarily is not saying no. To that question.
That it could be done. It's possible there could be a second trial required, and I'll explain. If all of the work is done in advance, then obviously we don't need a second trial. The other way to go about doing it where it's possible is like they did in the Buckley Towers case, where the verdict form specifically identified the actual cash value, the replacement cost value, and the ordinance and law number. And what happened on appeal there is the appellate court said, you don't get ordinance and law because the work wasn't done. You don't get replacement cost value because the work wasn't done, but you do get actual cash value. So that would be the other way to go about doing it once all of those items are established.
But Gensler, you chose to define actual cash value as the cost to repair. And, under different policy language, the law and ordinance coverage could be very different from the actual cash value coverage, right? You have specific policy language here that says the cost to repair. And there's no such, you can't do illegal repairs, right? The cost to repair here may be the same number as the law and ordinance coverage just based on the facts of this case, right? And maybe there's cases where they'd be different, but there can also be cases where they just come to the same number. And here there is no cost to repair that can legally be found other than just replacing the roof.
There isn't, Judge, but that doesn't matter for our purposes because SFR stipulated a trial. It was not seeking O&L. It was not seeking RCV. It was only seeking actual cash value.
I know, but cash value is defined as cost to repair, and there's only one legal cost to repair here. That's what I'm saying. You might have situations where the law and ordinance, gives a very different number than actual cash value, right? Here you gave very specific definitions in your policy that your company wrote. And it said cost to repair, and there's only one legal cost to repair here.
Your Honor, I see my time's expired. If I may answer your question.
Go ahead.
The reason is that the actual cash value that Tower Hill has to pay is the actual cash value of the insured loss, which is the damaged property. Once that's established, then the ordinance and law kicks in if necessary. But here, this trial focused on that insured loss, and that's what we need to find. That's what was not put into evidence, and that's why the directed verdict was appropriate. Thank you.
Thank you, counsel.
Thank you.
Appellants, 3 minutes and 46 seconds. You may proceed.
You're muted, counsel.
You're on mute.
I just circle back to where I started. All of these cases deal with if an insured fails to prove ACV, there's summary judgments appropriate, or there's a failure to prove a breach of the policy. You look at the verdict form here. I think question one was, did the insured prove that Tower Hill should have paid more than the deductible? I think it was something generic like that. So there are two ways based on the limited world of cases that we have, the limited universe. We have Vasquez, which deals with matching tiles. I think that has nothing to do with this case. This case doesn't deal with matching roof tiles. It deals with, whether or not it needs to be replaced in the ordinance and law coverage. So, you have a breach for a denial claim, you prove the coverage, and then according to TO, the loss settlement provisions are off the table. Here, the way this should have gone forward was, this was the ACV that was tendered. Did SFR prove that the ACV was underpaid, and that would have been the breach. The fact that the parties just missed the mark and focused solely on the damages issue, it can't be cured by this court. That was the constant motion for directed verdict before, during, after trial. It was argued extensively, and I just like to point out that even the case cited by the trial judge, which is that CMR construction case, that case turned on the failure to establish an amount of ACV damages, and it was a breach. They failed to prove a breach, and I could go through all of the other cases. So I think they're missing the mark. I think it's a square peg trying to be, pounded into a round hole. I think that, just based on the damages that were presented, the testimony, the fact that the jury wanted a calculator, I think that they had enough information. They're allowed to use their common sense. They had Tower Hill's estimate back there that was originally, resulted in a 21% deduction. So at this point, we would like the court to reverse the directed verdict as to damages and remand the case back for a new trial, where hopefully the issues can be hashed out and teed up a little better. So thank you for your time. If anyone has questions, I'm happy to.
Okay, thank you, counsel, both for your arguments, and we will be in recess.
Have a great day, Your Honors.
Thank you, you too.
Bye,
Thank you.
Ryan. Good to see you again.
Bye-bye. Good to see you.